Started. It's good to see everyone introducing themselves in the chat. And so I have Tara here who's going to help me monitor the chat. So we'll take questions at the end of the class, and we're recording everything. And so we're also going to try to keep people on mute just to cut down on background noise. And so this is part one of the class. So this is an hour-long class, and then we have part two that's going to start at 2:10 after a 10-minute break. And so with that, I will go ahead and start on our first part, which is inspecting violations and giving notices. And so this is the first part where we start investigating a potential violation and start getting in touch with the property owner to get the ball rolling on doing enforcement. And so violations are not going to be black and white. There's no one size fits all violation, and every situation and property owner is different, and so your experiences are going to vary, but what we're going to try to do is establish a consistent process so that no matter what happens, you have a template to go back to and that you can handle things in a way that is consistent, and so that you treat everyone fairly and hopefully come to a resolution without having to go to court. And so going to court would be the final step that we would not want to see happen, but it is kind of the worst case scenario. And so we'll go over some things that you should know about doing that in the second part. So first, what is floodplain management? So technically, it's the community-based effort to prevent or reduce the risk of flooding, resulting in a more resilient community. But Steve, who used to be the NFIP coordinator, now Tara is in that position, but he used to call it a stick to beat your neighbor. And that is because a lot of violations start with neighbor complaints. And so this is something that we've seen many times. Even if we'll start investigating a violation, sometimes it will kind of open a can of worms with neighbors complaining about each other and causing those things to come to light. But we do have to investigate violations as soon as we become aware of them. And that would include us doing our audits. And so a violation is any development that has occurred within the special flood hazard area that does not meet the minimum requirements of local floodplain regulations. And so if it doesn't have a permit, it is a violation. So anything that's unpermitted, every single development in the floodplain should have a permit. That is a separate permit. It's not part of the building permit, although it can be. If it is, it should have a separate section, but basically it is its own permit that ensures that it is compliant with your regulations. And this is important because violations that have gone unpermitted can be vulnerable to flood damage. It can make insurance more expensive, and it can cause FEMA to impose sanctions on the community if it's not dealt with. And so you're not going to deal with FEMA putting sanctions on your community if you're doing everything that you can to rectify the situation and gain compliance. This is really only for communities that choose not to deal with it for some reason. And so we'll go over what that should look like, but you shouldn't necessarily worry about that. It's just another one of those worst case scenario outcomes. And so again, development is any man-made change to improved or unimproved real estate. And so improved or unimproved real estate is basically all real estate that covers everything. And then there's a list that describes what could constitute development: levees, mining, dredging, grading, paving, all of that. But this list is not all inclusive. So it would be any change. And so repair and maintenance would be included in that. So a lot of people don't know that sometimes, that maybe roof maintenance or something like that, replacement of a driveway slab, that kind of thing is development, and it should have its own permit. So something like that would be easier to permit, but it should have its own permit even if you're just reshingling the roof or putting a new driveway slab that it's exactly the same way it was before. It should have its own floodplain permit. And so again, that's usually easier to permit, but it is required unless you specifically exempt it in your written administrative procedures. And so we'll be talking a lot about written administrative procedures today. It's kind of a big part of this, and I definitely recommend that you should have those to accompany your ordinance. So we do see a lot of signs like this throughout communities about permits being required, but they don't necessarily say floodplain development permits. And so doing that kind of outreach to all of your properties in the special flood hazard area about permitting is important. I think everyone should just be doing mailings to those properties, maybe annually. And you should definitely know all of those property addresses in case something happens and you'd have to go out and do substantial damage assessments, something like that. Having all these property files so that way you can keep track of them as permits come in for floodplain development, because we need to track substantial improvement over the course of a year or even longer than that if you have standards for substantial improvement. So doing the outreach can help you avoid violations in the future, because a lot of times people are just completely unaware of floodplain management and permits, and they should definitely know that they are in a special flood hazard area, although Kansas does not have laws about disclosing that. We will talk about that a little bit later in part 2. But yes, doing outreach can help you, because we do see sheds pop up often in the special flood hazard area, especially when we're doing audits. And this is kind of a smaller type of development that just goes unpermitted. People don't think about getting permits for something as small as a storage shed, but again, all development needs to have a permit. And then there are special requirements for accessory structures like this. And so, again, doing mailings to your property owners in the special flood hazard area, and also maybe these companies. So there are plenty of these companies that will just deliver a shed. People can just go pick them up or they'll be delivered. And then nobody does any checking on permitting or on areas of floodplain. So if you send a certified letter to a company like this that produces these sheds and then delivers them to people, if you send them a letter about permitting requirements and special flood hazard areas and where they're located, people can't really come back and blame you for them having a violation, or the shed company can't really say that they didn't know about these things if you go ahead and do that outreach. And again, we want to avoid issues. We're always out trying to find solutions and not cause more issues. And so special flood hazard area accessory structures have to be permitted. It might include a variance. Flood openings, properly anchored, all of that, flood damage resistant materials. So the more we can get the word out there to these companies and property owners, the better off we'll be. And so what gives you the right? People really don't like when you come onto their property and tell them what they can and can't do with their property. So it's important that you know exactly what authority you have to enforce floodplain regulations. And so in Kansas, we have these state statutes that authorize that specifically for floodplain management, and then a few other applicable state laws about dangerous structures, abatement, insurance proceeds that we'll talk about a little bit. So you do have the right to adopt and enforce floodplain management regulations through the state, and then that is codified in your ordinance where it's adopted, and then whatever it says in your ordinance is what you have to enforce. So take a good look at your violations section and exactly what it says on enforcement. That, and there are other state agencies that might have permits that are required, like the Division of Water Resources has state permitting for stream development. Kansas Department of Health and Environment has their own rules for certain types of development around streams and in floodplains, like septic systems, and some of those rules are more restrictive than floodplain management. So when you're investigating a violation, it's good to go ahead and look at the type of development and what other state or federal permits might be required, and then having those people and those agencies copied on your violation letter and involved in the enforcement process can help you with enforcement and getting compliance. So with that, here is the state law on insurance proceeds. And so this is a separate ordinance that you can adopt. There is model language that can be adopted through the Kansas League of Municipalities. They came up with this language. And so basically, if a structure is substantially damaged and they have an insurance claim, 15% of that can be sent to the city to be held and to bear interest until that structure is brought into compliance. And so if the community is holding on to that 15% of their insurance claim and their payout, it's a good incentive for them to get into compliance. So this is just another tool that we have that you might not know about to help gain compliance by kind of holding that over their heads. And so enforcement starts really when you become aware of the violation, no matter how that happens. Sometimes anonymous complaints, like I said, neighbors telling on each other, happens a lot when you visit the property. So we do recommend that you just sort of drive around and keep an eye on your floodplains and kind of look for development, and then be aware of permitting and try to look for permits and make sure that people are permitting their development, because the sooner you deal with a violation, the better. If you can catch it before it's completed, you're more likely to get compliance. It's going to be easier to get compliance. And then when we come to town, we do audits of your floodplain program. And so we'll look through aerial imagery to look for new development in the floodplain, and then we'll ask for permits on that. So however you become aware of it is when we need to start dealing with it, and when you have a responsibility to start investigating it and getting compliance out of it. So we had a city clerk once tell us that she would not investigate a complaint if it was anonymous for some reason. I don't know why that is, but that's not what it says in the violations section. It says we will investigate and enforce any violation anywhere in our floodplain. So that's what we need to be following and doing. And we've heard a lot of excuses for people not wanting to enforce regulations. I don't really know why. There isn't really an excuse to not enforce regulations or any free passes that FEMA would give you for not doing it. I think B, I'm too busy is the most common one that we've heard, but not upsetting anyone. It's already been built. Small city politics because that person knows somebody or something, or protecting the community from FEMA by not enforcing FEMA's rules. You're definitely not doing anyone any favors by not enforcing FEMA's rules. And so again, when we do an audit, we need to find permits for all of these things, or you're going to get retroactive permits for these things to get them in compliance. And we might end up finding out about violations later on down the road as people get insurance policies. So I'll talk a little bit about that. It may have changed a little bit with risk rating 2.0, but really FEMA doesn't give any free passes on any violations. The rules are that they have to be enforced as soon as we become aware of them. And so the key to enforcement is consistency, because we need to treat people fairly and have equity, and that way we will avoid issues. And that's, again, where written administrative procedures come in. If we follow everything the way that it's written out and that we say we're going to do in our procedures, then no one can say that you've treated them unfairly or that you're discriminating against anyone or any of that, because we want to avoid that. And people might use something like that to try to get out of correcting a violation or in court. So we will talk more about written administrative procedures, but another tool that you have that can help you with enforcement or investigating violations is aerial imagery. And so, like I said, when we do audits, we look at aerial imagery, and I look back through the last couple of years to look for new development, and then we ask for those permits. And so if you become aware of a potential violation, or if you see something, however you become aware of it, you can look at aerial imagery over the past couple of years to try to figure out when it was constructed, and then try to look for a permit in your permit records. So As we start investigating a violation, we want to start a violation file, and that is where we're going to keep all of our documentation. And so aerial photos like this can be kept as part of that record. We've seen manufactured homes that have been stored in the floodplain this way, junkyards, lots of sheds and accessory structures that have come up over time. And so you can make something like this, you can make a street map and keep all of these things together and then take them with you to the site. And that might help you find the specific location, and then you should be able to see what it is you're looking for. And then, yeah, definitely want to over document everything. Document everything and keep all of it together in one place, because people might complain about you to other officials. Or again, you might end up having to present this to your city attorney or something like that. So hopefully it doesn't come to that, but we want all of this documentation in case it comes up in an audit, or, you know, as I said, it goes to court or something like that. So just over document everything. Also firms, making a ferment, it's pretty straightforward. There's several ways to do it, but you can create this to help verify that your development or potential violation is actually in the floodplain. And then, like I said, make a street map to compare it to make sure that you're going to the right location. And so, yeah, you're creating a locator map and a floodplain map, finding the right address, and then keeping all of this documentation in your violations file. So here's an example of something that we would see in an audit, or if you become aware of something that has happened in the floodplain. So between 2011 and 2014, in this particular slide, there is a new gravel driveway that goes pretty far back on this property. There's a new structure that you can see. And then some trees have been removed from the riparian area. And so this is something that could help you, again, narrow down the construction date, which is important, and something to keep in our violations file. Again, something like a new structure, whether it's residential or non-residential, is going to need a permit. And so you can take these couple of photographs, put them in your file, and then compare it to other aerial imagery. So there's lots of imagery resources that we can use. So Google Earth has a historical aerial imagery feature. There's the Google Earth Way Back app that might have other photos if you're looking for a specific time period. And then the Data Access and Support Center, which is called DASC, is a Kansas GIS portal, but there's lots of available photos that I use for my audits, and because it can be hard to narrow things down to a certain time frame sometimes. So you can go in there and there's different types of satellite imagery that's high resolution, ortho imagery, NG 911. So I suggest you can just going in there and looking through their catalog of photos if you are looking for something specific. And then going to your county appraiser. So there's lots of good reasons to have a working relationship with your county appraiser. It can come in handy for getting market value, for determining substantial improvement or substantial damage if something ever happens. So you can have that information ready to go via property tax records. Also, when people do construction, they might have data on the construction dates for property tax information. So that is another resource to find exactly when construction has taken place, because there might have been a map change. So be familiar with when your maps last changed and how they changed, because it could be a development that happened before it came into the floodplain or something like that. And in that case, it would be grandfathered in and it wouldn't be considered a violation. So that is another avenue that we can go down that might resolve an issue before we even have to go to the property owner. So doing that kind of homework ahead of time before you head into the field can help save you time and make sure that you are going there with good reason. And then you can have all of this, again, documentation, put it in your violation file and keep it in there. Okay. And then, so when you do go to the property, either you've gotten an alleged complaint from a neighbor or an anonymous tip, or you just seen something that's happened in the floodplain that you can't find a permit for, whatever the case may be, when you were going out here, we want to go to the site and take lots of pictures because we are in the digital age where we don't have to develop film or anything, and we can take a lot of pictures without any issue. And there's, lots of pixels and details. And that way we can document everything as fully as possible. Again, over document everything that you're doing. So here's an example of a violation. So this is a shed that popped up in the floodplain. So you can see the ground kind of sloping down from left to right. And so the right side is down into the floodplain and there's no flood openings on this. It also wasn't anchored. Not that we would necessarily be able to tell right when we get there, but later on in the investigation that came out, but we are taking lots of photos of what the development is and making sure that we are actually establishing that there is a violation of some kind here. And so this is a good picture, but we can't really identify exactly where it is. And so we need some establishing shots. So again, take as many pictures as you can and get as many landmarks as you can. So on this one, we have the numbers on the house. We have a fire hydrant. That's a good landmark. And so get a wide angle photo showing as much of the property as you can, and then save all of these. Don't alter the photos, save all of your metadata, because again, that could end up in court as well. So we want raw, unedited images to back up our entire case here. And so again, try to include as many landmarks as you can, fire hydrant, numbers on the house. A street sign is really the best landmark that you can get. So it proves that it's right there on this corner. And this was actually a house that had substantial damage. So you can see all the stuff sitting in the yard, but get any landmarks you can, get as many angles as you can, because we don't want property owners to try to say that it's not their house for some reason, or that you were somewhere else, because they will try to poke holes wherever they can in the case that it goes to court. So take as many pictures as you can, and then if it gets that far, you'll be meeting with the city attorney to determine which photos would be best to present the case. And that, if you can get a shot of the stream channel or the flooding source or the riparian area and its relationship to the structure, would also be good to include. But if you'll notice where we're taking these from, this is from the sidewalk, and then this structure is across the street, and we are taking this picture from a traffic island or a median in the middle of the street. And that's because we want to be careful about illegal search and seizure, which is another thing that could cause problems if you don't enforce things correctly. So where do we stand when we're taking the pictures? We want to be on the public property. We don't want to be on the curtilage. And so the curtilage is the property surrounding the structure. So the driveway, the front yard, all of that. Don't get into those areas because that will cause problems, and then you're trespassing. And so you don't want to cause any additional issues outside of the violation. We're just trying to get the violation corrected, however that needs to be done. But you don't want to give them any leverage on you trespassing or violating the Fourth Amendment rights, because people get all emotional about violations, and so you're dealing with individuals and they might use something like that against you. And so we don't want to deal with any of that on top of a violation. So again, curtilage is the surrounding areas of the property, and it's protected the same way the inside of the house is protected. And so if you go up into their driveway and you take pictures of the shed from there, it's kind of the same thing as if you had broken in. and done a breaking and entering, trespassing, that kind of thing. So unreasonable searches, we want to avoid that. Again, if you have to enter private property, we're going to follow our enforcement procedures on how that is done by getting permission or putting signage on a conspicuous location and then giving them like 5 days or something. So this started with the Boston Tea Party and the Stamp Act. So there were tariffs on goods that were being imported to the United States, and then stamps were put on the goods when the tariff was paid, and so that would increase the prices of good, and then they would use that money to pay British soldiers to enforce that law by breaking into people's houses and doing searches for unstamped goods. And so people didn't like that, and so it led to the Boston Tea Party and the Revolution and everything. So we want to avoid this issue by following written administrative procedures, meaning we're going to investigate things from a public area, and then if we have to enter private property, we're going to seek permission or follow our enforcement procedures on how that is done. So we have talked to floodplain administrators that don't follow this, have just kind of gone into private property without getting permission, and it's led to other issues. And so we don't want that to happen. Also, you might be putting yourself in danger. People don't want you on their property. And so especially if there is a no trespassing sign, then you're going to be having issues if you go there without permission. So that, and there's safety concerns here clearly. So we don't want any of that to happen when we're just trying to enforce a floodplain violation. So another thing that we can do, now that we're investigating a violation and we're going to the site, again, by following procedures, we're going to the site. Later on, we're going to probably be working with the property owner either by phone or by requesting a meeting with them. So if we show them a picture like this, it's like, is this your house? Is this where you live? And it's pretty clearly that same house via the mailbox and the numbers and everything else. That clearly shows which property this is. Do you live here? And they say yes, and then we can show them the violation pictures, and then we have that to back them up. So if we go and show them their house and then we ask about the shed, we lead up to it in a way that there isn't really a chance for them to back out of it. And then they kind of have to own up that, yes, this is their property and that's their shed. And then we have to deal with the violation. Because again, there are certain property owners that will try to get out of correcting a violation, especially if it's expensive. And so we just don't want to give them any leverage on that. And we're just trying to find solutions to these issues. So again, this accessory structure doesn't have any vents or anchoring. And so it likely doesn't have a permit if it doesn't comply with our regulations. And so again, with the metadata, we want unedited photos. They also kind of can't say that you photoshopped the structure in there or anything. And so how do you want to take the pictures? You can get a pretty decent digital camera for about $100 out of your budget. And then you would have this camera that you would just set aside for violations and maybe substantial damage assessments. Because someone might end up wanting to see the device, whether that's the property owner or in the course of litigation, they might want to take that device to look at it. And again, with the metadata and everything, so you might want to have just an inexpensive camera that you wouldn't mind parting with in case someone has to take it from you. So you don't want to use an expensive Nikon that could get broken or confiscated at some point. And so again, if you end up going to court or in the process of getting compliance of this violation, you might be working with the city attorney and having a pre-trial meeting with them, and they will explain to you what is good or bad about certain photos, and they will choose which ones should be used for enforcement. So again, take lots of pictures because it's free, get lots of different angles. You want some establishing shots, you want some close-ups as much as you can of the violation. Again, from a public area, or if you're on private property, get as many pictures as you can. But of course, we're going to follow our rules for going onto private property. And so save the metadata. And then when Steve was here, he used to like to point out that BTK was a floodplain administrator because he was the code enforcement officer in the Wichita area. And then he ended up getting caught by metadata because he sent this disk to the police, and then he was asking them if they could tell or catch him by using the metadata, and they said no. And then he sent them like a letter or something, and then they caught him that way. So definitely save the metadata. It is valuable, especially if you go to court. And then privacy. So kind of going back to the Fourth Amendment rights and other constitutional rights that we'll talk about a little bit more. Privacy fences are pretty common. And then sometimes you can just sort of see a shed or something behind them. And that might be how you become aware of a violation. So again, doing windshield surveys, being familiar with your floodplain and going through and looking for things, but we're not going to violate anyone's privacy by doing this. So a privacy fence is there, and people have a reasonable expectation to privacy from that. So we cannot invade that by looking through the slats in the fence or trying to look over it. So these pictures are pretty reasonable. They are taken from a public easement. They are not lifting the camera. These are at eye level. And so you can kind of see the difference between the two fences. The one on top is a bit taller. It's a 6-foot privacy fence, whereas the one on the bottom kind of has different lengths, and the bottom length being about 4 feet. And so the reasonable expectation of privacy between the two of them is a little bit different because of that height difference. And so we can take pictures like this without violating anyone's privacy, and it can be used again to help prove our case and be used as documentation in our violations file. And we're just kind of establishing that yes, there is an accessory structure here. As we're looking for permits, we're trying to get retroactive permits. And so again, a potential Fourth Amendment issue. So here's the issue. So Steve is demonstrating in the top photo, people raising cameras over the fence. If you can naturally see over the fence, that's fine, but raising your camera means that you're intending to violate the privacy of the privacy fence. And so it's your intent to violate privacy that is an issue. And that's where the illegal search and seizure can come in. And if you're taking photos of the violation that way, that's going to be a problem. It might be used as proof against you. And if you inadvertently capture any property owners or people in those photos, you could cause even more issues. And so that's what we want to avoid. The same thing with drones. They've been around for several years, but they're still kind of a newer technology, and they are somewhat unprecedented in the courts as far as their use. It's still newer tech, but so we don't have a lot of court cases to go off, but there are certain height requirements for helicopters in some states because of privacy laws. And so we have had some people say that they have commercial licenses and they can do whatever they want with drones, but if your intent is to violate a property owner's privacy by using it, then it's probably not going to hold up in court because again, our whole privacy thing is about intent. And so we had one floodplain administrator just kind of go rent one of those trucks with the cherry picker on the back of it, on the side of it. And then he would use that to just kind of climb up there and then take pictures over people's fences and stuff. And then, so that is an issue. We cannot have an intent to violate privacy. Again, we need permission to go onto private property, and that would include taking pictures or looking into private property. So the whole cherry picker situation is a little bit different than if we had a city employee going to fix a street light who was in a truck like that and then fixed it and saw a violation over a fence or something like that. That would be more legitimate because there is no intent to violate the right to privacy. And so That's kind of the main point here is your intent. And so just make sure that you're not violating that. And again, we want to document everything. Documentation is going to be so important if it does end up in court. So most situations can be resolved without having to go that far. That is our worst case scenario, but having good records is going to be important if it does not work out the way that you wanted to and you end up in litigation. Records are really valuable because someone might want to turn in a complaint about you or say that you're discriminating against them or treating them unfairly, something like that. So if we document everything and we're doing it exactly the way it says we're going to do it in our administrative procedures, then it really isn't going to hold up if someone is just making a frivolous complaint to get out of enforcing their violation or correcting their violation. And so again, with the whole neighbors telling on neighbors thing, that can happen where they say you didn't make my neighbor get a permit for their shed or something. And then if that is actually true, then you do have to go ahead and start investigating that violation as well. So anytime we become aware of violations, no matter how it is, then we have to start enforcing it. And so that happened like a year or two ago. We had an entire neighborhood in the floodway where someone was asking questions about doing improvements, and then it came out that they had done a lot of improvements on their property in the floodway without any no-rise certificates, and because it was so expensive, they were upset. And they said that we didn't make their neighbors do any permitting or anything, and so it kind of opened this whole can of worms where we were enforcing all of these floodway violations. And so that is something that can happen. So here's a couple of examples of violations. So this is aesthetically not nice to look at, but the violation is that there are no vents visible. So there's no flood venting on this. It's not properly anchored. It's not made out of flood damage resistant materials. And so if you see something like this, it's doubtful that it has a floodplain permit, because if it had an approved permit, it would be in compliance. And so that is an issue. And this one looks like it might be a violation. It's not anchored. It doesn't have any flood openings. But upon looking at this in aerial photographs and doing the investigation, this shed had actually been here for over 40 years. So it's a pre-firm structure. It's been somewhat maintained over time, but it was grandfathered in before there was a firm map or any floodplain management regulations. So again, going in and doing that homework on a structure or potential violation can help you resolve things by finding out that it's not actually in violation. It's just a legally non-conforming structure. So again, doing outreach about permits, any development without permits is a violation. And so doing whatever you can to get the word out that floodplain permits are required, and as well as other permits that might apply to a violation, such as DWR, USACE, so federal and state agencies. Again, outreach can help you avoid violations. So what's next? What do we do now that we have established that there is a violation? By doing whatever kind of investigation we needed to, as far as doing the background work and then going to the site and doing inspections, again, by seeking permission or however that went down. So you can blame it on me somewhat. We will talk more about blaming it on me and making me the bad person. So we at DWR want to back you up. So that is an option. We need to notify the property owner. So a stop work order is something that you can do if the work is ongoing. Again, it's easier to fix something if it hasn't been completed yet. And you don't need a special form for this. You can just use a community letterhead for notices of violation. And so you don't want to delay on anything, because again, it is easier to get compliance if it hasn't been finished yet, but the sooner you act on things, the better. And the longer you wait, the worse things are going to get. So this should be issued if construction is still taking place. So we need to notify the property owner of a violation as soon as we have established that there is one. And so we suggest doing this by using certified mail, followed up by a mailing affidavit, or you can do one or the other. But either way, we are creating this paper trail. We want documentation that the property owner was notified on this date, or that the notification was sent out on this particular date. Because if you hand deliver a violation notice, there is not going to be a paper trail, and that's not what we want. And a mailing affidavit might be easier and less expensive than certified mail, because sometimes people don't want to sign for certified mail if they think it's going to be bad news. And so a mailing affidavit works just as well. Basically, you just have a notary public witness that you have mailed out the letter, and then you have this documentation that you mailed out notice. And then it's harder for the property owner to claim that they never received the letter, or that they were never informed that there was a violation on their property. And so I will talk more about verifying the address, but we want to make sure that we are sending it to a specific person. But the first letter is a little bit different than the second letter of notification of violation. So we call the first letter a letter of allegation. And so this is the nice letter. And I actually just updated our template for this letter. So let me know if you'd like a copy of that. But basically, we have these pieces to a good letter. The location and nature of the violation should be clear and concise. We're going to try to avoid using any acronyms. So we should cite exactly where in the ordinance this is a violation of, which specific sections have been violated, and then possible outcomes of this, such as fines or abatement or insurance proceeds, and whatever else could happen. But most importantly, we're trying to get action out of this person. So we're giving them the option to meet with us, to speak with us, and telling them how they can apply for a permit to get it in compliance and what needs to happen to fix the violation. So we're trying to make it very simple, not too technical, and make it very clear what we want them to do, and then always give them a deadline. So we have to give them due process. We have to give them enough time to get it fixed, but we want a hard deadline for them to act on. And then it'll become an important part of our enforcement as far as having a timeline for exactly when we do things. So this is another good thing to have in your written administrative procedures, is exactly what timeline you give people. So the first notice of violation, 30 days, second notice, 30 days, whatever it may be for your community. But yeah, the letter of allegation can magically fix things sometimes, because we're just sort of saying there's an alleged violation. So you have established that there's something on this property and you cannot locate a permit for it. So you might want to say that. A search of our records could not locate a floodplain development permit. Floodplain development permits are required for all floodplain development. So just saying that you can't locate a permit might help kind of ease it, make it a little bit nicer sounding. And also, permits have been misfiled before or misplaced. And so if that's the case, it's an administrative error. And then that would be, on the administration, the person did it right. So that might help clear things out. Our template says something like, if you have a permit, then please produce it to our office, and then that could possibly fix it. You're also giving them 30 days to come up with a solution to either apply for a permit or remove it. So sometimes people will just go ahead and do that. They'll come in and apply for a permit, or by the time you go out to do inspections, it has already been removed. And then in that way, the problem has resolved itself before you even really get involved with the property owner. So it is a good tool to have. And then we need to make sure that we are sending it to the right person. So the street address might not be enough. You might want to include the parcel ID and the legal description as well. And so we want to send it to the actual owner of the property. So not a tenant or a renter. We can find that with the Register of Deeds, who exactly owns the property, because we don't always know who is causing the issue between a landlord and a tenant. And so the landlord would be the person paying the property taxes and taking care of these issues. So we would just let them deal with the tenant. So find the actual property owner. You can also request a limited certificate of title through your attorney. So you have a lien on the property that, again, would go into the property taxes if things are not fixed. And that's why we don't want to just send it to the person that's living there. And then again, certified mail or have a mailing affidavit for that. And if you're talking about a business or a non-residential structure, you can find the representative agent by going to the Kansas Business Center and then go to entity search and then find the resident agent, and then that person is authorized to receive mail and then act for the business. And Steve would like to point this out, that the resident agent on this business is the Corporation Company Incorporated, which is not a person. And so we have these different parts, again, to our violation letter. So I do have the template with these pieces in it, and that way you can kind of adapt it to your own violation letter. You can make your own template out of it. So you have an opening greeting, again, with the person's name, a specific person, and then the alleged violation. We're going to cite the ordinance, exactly what is in violation. Yeah, the citation. And then we have to request a meeting. So we want to meet with them. We want to find a solution, come apply for a permit. This is what's going to be required for this type of structure. If you don't, this is what can happen, your consequences, fining, abatement, whatever the case may be. So we'll look at some different parts of that. And then the right to appeal. So if you don't talk about variances and the right to appeal, you could be in violation of their rights. And that is something that is important that might not immediately come to mind for a violation letter. And so I put that in my template for the first notice and the second notice about the right to apply for a variance, but I included the fact that there is specific criteria for a variance to be granted and that they can find it in this section of our ordinance, etc. And that way they can look at what is required for a variance, because most of the time, like 99% of the time, a variance is not a good way to deal with a violation. They have to meet specific criteria for that, but we do have to tell them about this right to appeal. Again, we don't want to violate anyone's rights and create additional problems or give them an out on not fixing their violation. And then the deadline date, again, that's important because people will put it off. Steve used to like to tell a story about when he was a floodplain administrator that he sent out a violation notice, and then the person eventually came in to deal with it, and they were really nice about it and they wanted to get it fixed. They just didn't have a deadline date, and so they just kind of kept procrastinating. So that is something we want to add in there and make sure the deadline date is consistent every time we do this. So it's like a 30-day deadline between notice and the second notice, or whatever the case may be. Again, writing things out, a procedure that is consistent every time we do it. And then the conclusion at the bottom, your contact information and how to reach you, where to go, all of that. So here is an example of a bad violation letter. So we can look through this really quick. So this is the first notice. It's addressed to whom it may concern, which is not a good way to do it because that person cannot be subpoenaed. We want to address it to a specific person, find out whoever that person should be, put someone's name in there. Again, in case things get worse, we need all of this documentation in there. And then it says, as of now, you are in violation of the floodplain management regulations. So it says you are in violation, whereas violations are about development and structures. It's not about the person. So there's a really accusatory tone already going on in this letter, and violation is in all caps and it's in bold. And then it doesn't say what's in violation or what part of the ordinance. It just says this resolution number, and then it just goes into all of the consequences. So it doesn't tell them what's wrong. So basically this person would have to go into the resolution, into the ordinance, and then look through it, read through everything to try to find out what they did wrong. And that's just not the way to go about it. It doesn't request a meeting. It doesn't say anything. It just says, if you have questions, then call me. And then it kind of talks about getting a LOMA, which is sort of out of place. I mean, a LOMA is one way to resolve a violation that is totally valid, but you'd want to discuss the issue with the person and then go into the possibility of getting a LOMA as one of your possible solutions. It's not something that should go into the first notice. And then, yeah, it just has a phone number at the end of that. And so the only thing that's been blocked out of here is the identifying information, but that's not a good way to do it. So we want to be specific about what it is and how to fix it. Request a meeting, and the first notice should be nice. Again, the letter of allegation can help you fix things without having to even deal with something like this. And this letter actually didn't generate any action. We are trying to generate action out of people by getting them to fix things, come in, meet with us, and find a solution. This was just kind of just poorly written. So again, if you want a template for how to do this, I have a couple of them for the first and second notice. So again, there's no due date on this. It just says 30 days. We want to put an actual date on there. So 30 days from the date that you mailed it out, or however you want to do it. Just give them a due date so that there's a hard deadline. Because if you don't put a deadline, it can be hard to get to the next step, or response due by date. So however you want to write it, give them a date to respond by. And again, take a look at your violation section of your floodplain ordinance. It could be pretty lightweight and you might want to expand it. Or again, written administrative procedures is a document that accompanies your ordinance. There's a lot of procedures that are too long and specific to your community that can't and shouldn't go into your ordinance. And so we highly recommend having written administrative procedures that are specific to your community and tells people exactly how things will be dealt with, what the timeline is, how you're going to enter private property, seeking permission to enter private property. Again, if our model ordinance says if you don't give them permission, then we'll post a notice somewhere conspicuous on the property and then wait 5 days and then enter the property. You can also put inspections into the permit, and then that will give you right to enter property. So however you need to do that, just make sure, again, that you're not violating anyone's rights. And then make sure that your violation section is consistent with the other departments in your community. So you might want to look at their violation sections and see that you are following it consistently, because some violations will cross over between departments. So it might be a floodplain management violation and a setback issue. And so you can put it all in one violation letter together. You'll have more people copied on that letter. It'll back you up a little bit more if there's additional departments that are involved. And you might, just make sure that you're acting consistently between departments, because it can be confusing if they're dealing with two different violations on two different timelines. And again, due process. So giving them 30 days, giving them however long to go ahead and get that fixed. People expect this. It's in the 5th and 14th Amendment that contains language about due process, which again, the reasonable opportunity to correct a situation. The Supreme Court has ruled that due process clause of the 14th Amendment prevents state governments from infringing on the right to privacy. So 2 written notices in an appropriate amount of time. Again, no trespassing. Any violations that you're dealing with, you should also consider working with your city attorney on to make sure that they're in the loop, and to make sure that you don't do anything wrong. And again, document everything. So yeah, at least 2 written notices before you proceed on to any more harsh enforcement actions like fining or litigation or abatement or whatever the situation calls for specifically. So again, if you don't give them that notice, a couple of notices and appropriate amount of time, you might be taking away from their right to due process. So we want to make sure that we're respecting people's rights and not causing further issues. So like I said about making us the bad guy, you might want to copy your violation letters, copy us on them to us, send it to us, and then let us know, because you can kind of throw me under the bus at least and say that I'm kind of involved in this and making you enforce a violation, and sometimes that can help you get compliance. If you involve a state agency and your other departments or whoever needs to be involved, if you get a little more authority in there. So just let us know if you're going to do that, and then send us a copy of the letter so that we know what's going on. And that way we can kind of back you up, because if someone calls me and I don't know what they're talking about, that's not going to look good either. So just let us know first, and then you can tell them that I'm really mean and it's easier to deal with you than it is to deal with me. And so send it to us and we'll put it in our community files. And so again, with the state and federal agencies that might also be involved with a violation, the Division of Water Resources state permitting has slightly different rules from the NFIP. So if you're not sure about that, definitely check with Janelle at our Manhattan office to determine if a state permit is required, usually for something like stream development or fill in the floodplain, that kind of thing. And then getting us involved, again, either her or me for floodplain stuff, NFIP stuff, whatever you need to do to copy us on those and make sure that those other permits are also obtained, because it's in your ordinance that other state and federal permits will be acquired when they need to be. So inspecting violations and then sending these at least 2 notices are the first steps. And then the next step is to meet with the property owners and then come up with a resolution. Again, we want to find a resolution before we go to court, and there's lots of ways to do that. And meeting with the property owner to discuss different solutions is a good way to do it. So if you haven't signed up for the second part of this, that's going to start at 2:10. So we're going to take a 10-minute break before we start on that. It is a separate Zoom meeting. So we're going to get off of this one and then move to the other one, but we will talk about resolving these problems and taking issues to court. So I will stop sharing my screen now, and then we can move into any questions if there have been.
Thanks, Cheyenne. I haven't seen any questions in the chat. There's been a few comments and discussion, but did anybody have any questions?
Oh yeah, if you want to come off mute now and ask a question, that'd be fine.
Hi, Cheyenne, this is Katie Jardue in Miami County. You always provide such a good list of resources. Do you mind sharing like some of the ones I hadn't heard of that you had mentioned for images and using historical images?
Yes.
Okay.
So I can just go ahead and sign up or send out a mass email to everyone on this meeting with my list of stuff for aerial imagery, because that is a really good resource for looking at stuff without violating people's privacy rights, and then our templates for violation notices and stuff. So I will go ahead and send that out after the 2 meetings.
Thank you.
Mm-hmm. Okay. So are there any other questions before we break for 10 minutes? Okay, well, thanks for joining us, everyone, and I hope to see you over on the other meeting at 2:10.